Due to the unedited footage from the set of It Ends With Us, which was released by Justin Baldoni's legal team, and which many believe does not align with her statements, Blake Lively is displeased with Baldoni's representatives. That footage, which featured the very scene in which she lodged a complaint, did not reflect well on Blake according to numerous observers, and her attorneys have now issued a letter that essentially tells Justin Sawyer to remain silent. Next, we're going to delve into what Blake Lively's legal team has said in response to the emergence of that clip, as well as how Justin's legal team is countering. Once Justin Baldoni's team publicized the uncut footage from the It Ends With Us set, Lively's side made some remarks in the press. According to The Hollywood Reporter, within hours of Baldoni's team leaking that footage, Blake Lively's attorneys filed a request in the court overseeing her civil rights lawsuit to impose a gag order on Baldoni's lawyer, Freedman. They accused him of effectively perpetuating the alleged smear campaign against Lively by repeatedly engaging with the media, leaking information to sway public opinion toward his clients, and making false claims. On December 20th, 2024, Ms. Lively filed an administrative complaint with the California Civil Rights Department, the CRD complaint, a requisite step in exhausting her administrative remedies prior to filing suit. Immediately thereafter, through counsel, Ms. Lively provided the named defendants, the Wayfarer parties, a copy of Ms. Lively's CRD complaint. At the same time, Ms. Lively also issued the Wayfarer parties a cease and desist letter, the first cease and desist, demanding that they immediately cease and desist all unlawful conduct toward the Lively Reynolds parties and their affiliates, including their harassing and retaliatory media and online campaign against Ms. Lively. Immediately thereafter, and virtually every day since, Mr. Freedman has given television interviews, appeared on podcasts, issued inflammatory written statements, and leaked information to the Hollywood press and tabloid media. Those statements not only continue the campaign of retaliation that was the subject of Ms. Lively's first cease and desist, but they contain numerous new false statements about Ms. Lively and others. On December 23, 2024, in light of repeated instances of Mr. Freedman making unprofessional and false statements about Ms. Lively and the litigation she had commenced, Ms. Lively sent a second cease and desist letter, the second cease and desist, this time directly to Mr. Freedman. The second cease and desist directly addressed Mr. Freedman's ethical obligations, notified Mr. Freedman, as well as the managing partner of Mr. Freedman's law firm, that he had defamed and engaged in further unlawful retaliation against Ms. Lively, and demanded that he immediately cease and desist from making further defamatory and retaliatory statements relating to Ms. Lively. The second cease and desist lays out Mr. Freedman's false assertions and the evidence contradicting them, as well as the text of the applicable California Rule of Professional Conduct. The second cease and desist further explained that Mr. Freedman's statements, issued as part of an all-out media blitz to anyone willing to listen, were unprotected by the litigation privilege. Since the Wayfarer parties and Mr. Freedman received the cease and desist letters, they have continued their harassing and retaliatory media campaign with almost daily media statements or other releases to the press. Earlier today, the Wayfarer parties leaked a video to the media that they have asserted is designed to refute the allegations made in the Lively case, even though those allegations are now before this court in not one, but two federal complaints. They have further indicated that they intend to create a website to increase publicity around the exhibits filed in the Wayfarer case. In one of today's multiple statements, they stated that the website will contain all correspondences as well as relevant videos that quash her claims. As counsel for Ms. Lively has made clear, these releases only reinforce the claims Ms. Lively advanced in her original complaint and continue to advance the campaign of retaliation alleged therein. But there is a more fundamental problem with Mr. Freedman's litigation via press statement strategy. As Ms. Lively's counsel has attempted repeatedly to caution Mr. Freedman, federal litigation must be conducted in court and according to the relevant rules of professional conduct. Wayfarer's counsel have already been warned that Mr. Freedman's initial media blitz back in December violated various California state rules. His most recent statements, coming as they do on the heels of his having filed a federal complaint in this court, plainly violate Rule 3.6 of the New York Rules of Professional Conduct, which prevents a lawyer who is participating in a civil matter from making an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. New York Rules of Professional Conduct, Conduct 3.6. Here, Mr. Freedman is a lawyer participating in a civil matter before this court, yet he continues to make regular statements covered by Rule 3.6. His conduct threatens to and will materially prejudice both the Lively case and the Wayfarer case by tainting the jury pool because his statements are deliberately aimed at undermining the character, credibility, and reputation of numerous relevant parties, and likewise includes information the lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, thereby creating a substantial risk of prejudice not just for Ms. Lively, but for numerous other parties in the matter. Mr. Freedman's conduct is by design, not by accident, and this court should consider carefully his history of litigating matters in the press while evaluating his request to be admitted pro hac vice filed earlier today. It is worth asking whether Wayfarer's lawyers have any intention of abiding by Rule 3.6, or whether they intend to continue selectively releasing evidence without context or any opportunity to be questioned on that evidence in the public domain at the same time they purport to litigate this matter in court. Rule 3.6, of course, requires parties to decide whether they want a jury of their peers to decide their claims, or whether they prefer to let the court of public opinion do so. Doing both at once creates an impermissible risk of interfering with the judicial process, and it is not tolerated under New York law or the law of any other relevant jurisdiction. The court may exercise control over its docket and the litigants before it to avoid improper conduct by counsel, and it should do so here. The Lively Reynolds parties intend to seek an appropriate protective order to govern further proceedings in this case. But given the imminent harm caused by Mr. Freedman's misleading and selective statements and leaks, we respectfully request that this court schedule a hearing as soon as possible to address the appropriate conduct of counsel moving forward in these two related matters. According to The Hollywood Reporter, individuals close to Baldoni find it profoundly unjust to enforce a gag order after Justin was allegedly maligned by the New York Times in a piece that they claim cost him 3 jobs and hundreds of millions of dollars. All Justin wants, the source explains, is to reveal videos and text messages to demonstrate that the claims against him lack merit. The source also states, "It is astonishing that Blake Lively would engage in a smear campaign against Justin and then immediately request a gag order so that he cannot defend himself." As the letter indicates, Justin's team has been informing the press of their intention to unveil a website featuring his communications with Blake, along with pertinent videos. Their goal is to publicly salvage his reputation. Of course, Blake and her representatives are attempting to prevent this, and only time will tell what transpires. Moreover, the unedited footage from It Ends With Us that recently surfaced may not be the sole video material we end up witnessing. Since the release of this footage, Colleen Hoover, the writer of the novel It Ends With Us, has taken down her Instagram account. Prior to that, she had posted her support for Blake, stating on Instagram, "At Blake Lively, you have been nothing but honest, kind, supportive, and patient since the day we met. Thank you for being exactly the human you are. Never change, never wilt." Soon after the New York Times published its report covering Blake's complaint, she released this statement. This, however, is not the first time Colleen has stepped away from social media following a wave of criticism. During the rollout of the film, it became apparent that its promotional methods weren't doing much good for anyone except for Justin, because of the way he spotlighted the movie. Colleen, Blake, Jenny Slate, and Brandon Sklenar all encountered backlash for how the film was publicized. In particular, Colleen Hoover received a surge of disapproval from fans who felt that the promotional tie-ins and partnerships were too carefree for the book's heavier themes. One such partnership was a nail polish line, with Olive and June offering shades named Brave Blush, Lily Blooms, and Atlas, and there was also a duo set carried in Target. Colleen had additionally intended to release a coloring book inspired by It Ends With Us, but that plan was abandoned after a large amount of pushback. Last January, she addressed the situation on her Instagram story to issue an apology, writing, "The coloring book was developed with Lily's strength in mind, but I can absolutely see how this was tone deaf. I hear you guys and agree with you, no excuses, no finger pointing. I've contacted the publisher to let them know I would prefer we don't move forward with it. Thank you for the respectful discourse and accountability. Nothing but love." When the movie was released, the cast came under scrutiny for their approach to marketing, it telling audiences to wear your florals and grab your besties. Critics disliked these tactics, and Colleen Hoover apparently wasn't fond of the negative remarks. Unable to cope with the backlash, she deactivated her TikTok account around that time. Many now suspect she's once again avoiding social media because of the ongoing situation involving Blake Lively and Justin Baldoni, especially since she openly showed support for Blake. Considering her past pattern of stepping away whenever there's public criticism, it isn't shocking that she's once more absent from Instagram. This whole scenario is truly chaotic, and fresh twists in the legal conflict seem to emerge each week. There are numerous moving parts, making it appear that the end is nowhere in sight. For the time being, that's everything that has come to light. I'd love to hear your opinions on all of this, specifically regarding Blake's effort to silence Justin's lawyer and prevent the release of that website. Feel free to share your thoughts in the comments. I appreciate you all so much, and I'll speak with you again in the next video.